Okay, Ms. Archer, I guess you can start whenever you're ready.
Okay, all right then.
Sorry, I can email you the class list right now.
Okay, because I was wondering what happened.
Okay.
Yeah, I was wondering what was happened. Okay, send it to me then. Did you send out the class schedule also?
Boy, I wonder.
No, I don't think so. I haven't seen it.
All right, I can forward that to one. Forward that to.
Yeah, who was on? RC.
I see. We have Hussein
Darcy.
Mueller, Darcy, and Tessa Delaney.
Okay, all right.
Hold on, who? I know Tessa. That's my family.
It says Tessa Delaney.
Yeah, and you have Darcy Delaney, yeah. Tessa Delaney and Darcy.
Mm-hmm.
I'll meet a little. That's probably my family. I know her though.
Yeah, but she online, so ask if she's your family.
I think she may be married to my family.
Oh, but she's
I am
on.
married to a Delaney. Yes. Hi, everyone.
Hi. See, she's married to one.
Yes. Okay, good. I was born a Delaney.
Oh, Jesus.
Is that you right? Long time.
Yes, I am fine. Where's your partner in crime? Is she registered for this class?
Shalisa?
Yes.
Oh, which one?
Yes, Shalita.
I don't know. I know she had her kids, so she may be a little late.
Oh, okay. Okay.
Good night,
All right.
everybody.
Okay, who else is on? I think it's just you two for now, so we can get started. So you see that chapter one is just a recap because this whole course is about different vehicles that can be used in company law. And for most persons who would actually form a company is all a part of a structure. So chapter one just goes over what we would have learned in company law one, which is what a company is for those who forgot. So I know Darcy remembers, and Tessa, I'm sure you're well aware of it, correct?
Yes,
I know
ma'am.
it. Okay, all right. So check your email. I just sent you a question. We're going to start the discussion with that same question.
Miss Austin, did you send me the question too? It's Amberzine.
Let me see. It says 7 more. Let's see. I don't see your name here. What's your last name? Let me see.
I got it.
FAGQ.
I just got it. I got it.
Okay.
You got it?
Yes, ma'am.
Okay, but you under? I see Daniel. Okay, all right. All right, so you have the question. And I'm sure I don't have to give you a lot of time to think about it. Who wants to start? This is a very easy question now. Come on.
What is this? Solomon versus Solomon?
Solomon versus Solomon, yes. You do know that case.
Yes, ma'am. I can remember the case last year. Hold on, let me try to find my notes from last year. So we just want to have a discussion. That's it.
Yeah, because chapter one is just going over company law one.
Okay. And what the statement is saying is whether or not a company is a legal entity and not a legal person. Is that correct?
No.
Oh. Let me read it again. Sorry.
You saying the word legal twice.
Oh, sorry. Legal entity and person.
Yes.
I would say it's a legal entity.
Yeah. So in the statement made by the judge, he was saying either or. He was saying either the company is a limited company, which means it's a legal entity, or it's not. You can't be both. And then okay, let me let y'all discuss it. Because if I discuss it, then it's not the same as you trying to recall what it meant. Go ahead.
From what I understand, it is a legal entity. And so in this case, it really just goes to show that, it has its own actions and is liable for its own actions. Its members and its officers and principals are not liable for the business conducted by the legal entity itself.
Okay, so in the Solomon case, what was being argued? Okay, I just sent the second question. Oh, this is gonna be fun. Okay, let's go back to the Solomon versus Solomon principle. So we know at the very beginning when we started talking about companies, we said that a company is formed for different reasons, which we all know. It could be for charitable purposes, it could be for economic reasons, or it could just be where someone wants to make sure that all the liability doesn't rest with them. So that's why they would form a company. And we know that a company becomes a legal entity once the articles and memorandum have been filed and they receive the certificate of incorporation. And we know that there's a difference between being a sole proprietor, being in a partnership, and being a company. So now I need you to tell me what's the difference between the three and what are the advantages or disadvantages. So let's start first with Darcy. If you're a sole proprietor, what are the advantages? Remember, we did this on the board. We had a big chart. What are the advantages of being a sole proprietor?
You get earn all of the profits. There's nobody to
Yes.
share. You're the sole authority maker.
Mm-hmm.
COVID happened since Masacha. You gotta excuse me. It was a long day.
Come on, Tesla could help you. Sole proprietor. Remember what I said in class when we did this? Sole proprietor, look at all the Bahamian-owned businesses, the small ones that have closed that the Chinese have purchased. Remember that story? When they discussed that in class? In 2019? That's too far gone. Since COVID, you can't remember. So the first thing with a sole proprietorship is that he owns the assets himself. All the liability extends to him. Any matter that requires a suit, he's personally liable for it, and all of his assets are liable if it exceeds what he has input into the company. There are some advantages. The advantages are he makes his own decisions. He doesn't have to answer to anybody. He can open and close his shop whenever he feels like. And of course, he doesn't have a lot of paperwork because he doesn't have all of those requirements as a company, all of those statutory filings. He doesn't do any of those. The only thing he may have to do is if his turnover is over 100,000 is to register with the Inland Department of Inland Revenue. But other than that, right, he makes his own decision. He is his own boss. He answers to nobody.
It's less costly for him.
And it's less costly, yes. Now, in a partnership, it's a similar situation whereby all the partners are jointly and severally liable. So you can go after one partner, you can go after all. And normally they're governed by a contract. And so normally the contract itself determines how they will deal with liabilities. Again, they are still personally liable, even though it's a partnership. A partnership and a sole proprietorship, when someone dies, what happens? The sole proprietorship, if the person dies, what happens?
That's the end of the business, eh?
That's the end of the business. And in a partnership, what happens?
It transfers to the next person, I want to say.
It depends on what's in the agreement.
In the partnership agreement, yeah, that's correct.
Partnership agreement.
Yeah, because you got all kind of things.
They could set it up however they want to set it up because it's a contract, it's a business arrangement. But of course, you have a company. We all know on one hand, a company is very costly compared to a sole proprietorship or partnership. It is costly. And of course, there are lots of timelines because there's a lot of regulatory filings to be done. You also need an auditor to audit your books. versus a proprietorship where you could just keep your little pieces of paper if you're under 100,000 and just keep and go from there. But forming a company gives a sole proprietor more comfort in one instance, because now his liability is only limited to what he has paid in capital. A company has perpetual succession. So it can enlarge, it can downsize, he can die. It keeps going on and on. You can restructure it, the company still exists. As long as you're paying the fees and as long as you're making money and you have not decided to go into voluntary liquidation or the creditors have put you in involuntary liquidation, the company goes on. Now, like I said, one of the main disadvantages is the cost. The cost of forming a company and the form of meeting all your regulatory requirements and filings, and also having an audit done. That's another cost. But an advantage to that is in a private company, you can actually then invite other investors. So you have more opportunity to get capital if you form a company. And then you could take a company from being a private company to a public company based on your growth and your expectations of what you want to do with the company. So when you form a company, it is different from a sole proprietorship because a sole proprietor is just that one person doing a trading as. Whereas when you form a company, you form a structure. And in that structure, you have at the very top, the shareholders, and then you have the board of directors. And the board of directors are responsible for the day-to-day management of the company. So now let's go back to the first question I sent you. In the case of Solomon versus Solomon, he said, either the limited company was a legal entity or it was not. So he said in the case of Solomon versus Solomon, you have to decide which one was it. Is it a company or is it not a company? So Solomon had already filed all of his documents to incorporate his company. He had already received his certificate of incorporation. So then the answer is, it was a legal entity. And he said, if it was, that means that the business, all the assets in the company do not belong to Mr. Solomon. It now belongs to the company. And then he said, if you're saying that it is not a company, that means it is still a sole proprietorship. He said there was no person and no thing to be an agent of at all. Because remember now, agency comes so when you have a parent and a subsidiary. So he was, if it is not a company, then it's a sole proprietorship. It's not in an agency relationship. Mr. Solomon was not an agent of the company. And he says it is impossible to say at the same time that there is a company and there is not. So you can't say there's a company, there isn't a company. Either it is a company or it is not a company. So we know that once you file your mem and arts and you receive your certificate of incorporation, then you are a company. The assets that belong to that company no longer belong to you as a sole proprietor. You are now a shareholder. And then you take instructions from the board. Does everybody understand how that question, what the question is all about, that statement that the judge made? You have to decide first whether it's a company or it's not. And if it is, the assets belong to the company. And there's always a question when it comes to a company as whether or not that company is acting as an agent. And if it is acting as an agent, then you have to decide if it is acting as an agent, who owns the company in terms of making its decisions. So in the case of Solomon versus Solomon, Lord MacNaughton said that the company is at law, different person altogether from the subscribers to the memorandum. And though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are managers, because that's what it was in Solomon. He was no longer the sole proprietor. He was a shareholder, but he's also the manager. And at the same hands receive profits when he's acting as a shareholder. The company is not in law the agent or the subscribers or trustees for them, nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the Act. So the whole Solomon principle, it affirmed that a company is not per se an agent of the shareholder. Even if the control is actually concentrated in one shareholder, as in Solomon. So even though the control was with him, because he had formed a company, it was a separate legal entity. Even if that one person owns all the shares of that company, it does not make the business carried on by that company his business. It's still the business of the company. So once you create that company, it becomes an independent legal entity. Any questions? Any questions?
I only would like to get a little bit more clarity on the agency relationship. I know you said that it comes into play when subsidiaries and parent relationships are involved. And so it doesn't really apply in the case of in certain relationships. But if you could just give a little bit more, I guess, understanding on that, that would be appreciated.
Okay, all right. So one of the principles of company law is that a subsidiary is not an agent of its parent. But there are exceptions to the rule. And those exceptions is one, when the court determines that there is an agency relationship between the company and a shareholder, and that's always based on facts.
Okay.
And the second exception is when creditors state that the company is a mere facade, a sham. It's just set up in order not to pay its creditors. So even though you may have a parent company and the parent company owns shares in the subsidiary, and by being a subsidiary, it gives the parent company that power to appoint directors and to say how the affairs are to be conducted. But that does not make it an agent. So the courts have determined that if you want to say that there is an agency relationship, there are certain factors that they look at, and it was established in the case of Smith versus Birmingham Corporation. And it says, to determine if there was an agency relationship, they asked these questions. Who was really carrying on the business? Who received the profits? Who was actually conducting the business? Who appointed those persons? Who was the head and brains of the venture? And who was in effective and constant control of the business? So in those instances, if the answer to those questions are yes, then they say that there is an agency relationship.
Okay, thank you.
Okay. So whenever you think of Solomon versus Solomon, always picture in your mind a company versus an individual. There are advantages and disadvantages to both, whether it's a company, an individual, or a partnership. And you know that you form a company for different reasons. Same way you could form a partnership for different reasons. And one of those could be you want to be in control. You want all the profits for yourself. But on the opposite side, you also have all of the liability. So when you have a company, again, there are advantages and there are disadvantages. Always remember, a company is not an agent. In order for there to be an agency relationship between a subsidiary and its parent, there are questions that the court will have to seek the answers to, and is all based on facts. One of the other exceptions besides an agency relationship is when the courts will go behind and will be called pierce the corporate veil. So look at the second question I sent to you. I think Tessa could answer that one this time. You received it, right? Yes, I did.
Yes, I'm looking at it.
Yeah.
I'm looking at it now.
Okay.
So it's just is the question just in the case of whether piercing the corporate veil can be done, or is the question more so just about in what instances does it apply?
You can answer it both ways. So take a stab at it.
So as far as I understand it, there are a variety of instances where the courts can pierce the corporate veil, and it's really with regards to how the company has been managed. Has it been operated like a company? Has it been maintained like a company? Have the relevant filings and statutory obligations been met? You know, if it has, for example, if it has a bank account, is it being operated like a company's bank account, or are the finances being used personally by the shareholder? Those are instances where, you know, the courts might say, well, this company isn't really being operated like a company. So is it really a legal entity in and of itself, or is it just a fake or a sham company?
Okay.
And so in that case, they would essentially not regard it as a legal entity, and they can go after, they can go and look towards the owners of that company.
Okay, let me see if I can find one of the easy cases that you probably can find online. Let's look at Jones versus Lipman. At the end of your chapter, you see there are cases. I think Jones versus Lipman is number 15. See if you can find that online. And Darcy, you could start by telling me what that case is about. Jones versus Lipman.
Jones versus Lipman.
Yeah, Lipman. You found it, Tessa?
I think so.
So.
Is it just, I can just look it up on Google, like it's not
Yeah,
something
uh-huh.
that was sent to, okay.
Yeah.
I just wanna
on
make
the
sure I'm in the
Google.
right place.
So it says, is there any particular source you want us to look at? We can find any source.
Yeah, it's off.
Okay, it says Mr. Lipman contracted to sell a house, and then he changed his mind.
Mm-hmm.
Refused to complete the transaction,
Mm-hmm.
and he tried to avoid certain obligations, I would say. And he tried to use a company to avoid doing this.
Mm-hmm. And what did the court held?
Judgment.
What did they say? Then they said that they said that the company was a sham.
Yeah, the company was shammed. So Mr. Who was Lipman or Jones? Lipman was then liable.
Mm-hmm.
They went behind the corporate veil.
And they ordered, right, and they ordered specific performance of the contract. Which means the contract had to be performed.
Even though
So-
he used the company.
Go ahead. Mm-hmm.
No, I'm asking you, even though he tried to use the company to perform the contract,
Mm-hmm.
when it was found or argued that it was a sham, the courts ordered that the contract be performed anyway.
Right. And so in that instance, the lifting of the corporate veil was said to be an exception based on fraud. So that's one instance where the court would have lifted the corporate veil is based on fraud. See if you could find the case of FG Films. Let me see if I can find it on the list here. Number 11. At the back of the chapter 1. FG Films Limited. You found it? 1953. Tessa, you found it?
Yes, ma'am, I'm reading, just reading a
Okay,
brief
all right.
overview.
Just making sure you were reading. I'm looking up another case.
So in this case, it was an agency relationship.
Yes.
Okay.
So courts have also lifted the corporate veil by finding there's an agency relationship. So what happened in this case in FG Films?
So what I'm reading, it basically just is an agency relationship where an American company held the shares of a British company, but the British company didn't have any real structure. There wasn't any resources. It didn't have an address or an employee. So it basically it didn't properly, any sort of business that company tried to do was rejected because technically it wasn't properly formed.
Exactly. Exactly. So in that instance, they declared that it was an agency relationship. But there are a lot of critics who said that this agency relationship could really apply to any company where members control the company. And so from the legal side of it, it's very doubtful that that case itself proved that an agency, like it didn't meet all the criteria for an agency relationship and for the corporate veil to be pierced. Now we go back to the other one that Darcy did, which was on fraud. Do you think based on, because Darcy hit on it, do you think based upon how that arrangement was structured, do you think from a fraud perspective, the court should have pierced the corporate veil? Darcy? You really think they should have pierced the corporate veil based upon what you read?
The Lipman case?
Yes, and Lipman. You alluded to it, you know. Go over it again.
Yeah, 1 second. Next class, I gotta get dual screens.
Huh? You
Next
need
class,
dual experience?
I flipping back and forth. Hold on.
Oh, okay. This COVID time, you have to get with the time.
I need the next monitor to work.
Oh, well, I have two. Couldn't make it without two. I get two at home and two at work. You need many screens.
Okay, so you repeat the question for me, please.
Okay, so I was saying to you, based on Jones versus Lipman, remember you were saying that the company, there was an agreement between the two parties to sell. And he tried to get out of it by conveying the land to a company, which he formed just for that purpose, to get out of it. And then remember you said that the court ruled that it was a sham. And then they asked for specific performance. So my question to you is this now. Hers was an agency relationship, right? But it still didn't follow the 6 questions that was set out in the case of Smith and Birmingham as to the answers to form an agency relationship. So I said, now let's go back to your fraud case. Do you really think they should have said that they were piercing the corporate veil in order for this transaction to be completed? Was it really fraud? Remember now, the whole point of Solomon versus Solomon and that principle being established was that a company is a separate legal entity. And so by it being a separate legal entity, that is how they call it, sacrosanct to what company law is all about. So the question always arises, why are we piercing the corporate veil? Because if you start piercing the corporate veil for many different reasons, then what's the purpose of having a Solomon principle if there's so many exceptions where people could go behind the company? So we know one is agency, and that has to be determined based on the facts. So the second one was the one which you came out first, which was fraud. And you did the Jones versus Lipman. I want you now to go, I want you to go and read the case, look it up now, It's a case called Trustor AB versus Smallbone.
But with the Lipman case, I mean, and you saying should they raise the Paris the corporate veil because of fraud? I mean, and if this guy,
Was it my question then is, was it really fraud?
I mean,
Is it because-
if he using the company specifically to avoid certain things,
No, but look at it like this now. Say that was you and I in this arrangement now, right? And I decided to form a company so I don't have to go into this agreement anymore. So we before the courts now, and the courts say we're gonna pierce the corporate veil, right? Because the formation of the company was for fraudulent purpose. Is that really piercing the corporate veil? Because then you turn around and you say, perform the agreement. Is that really piercing the veil?
well, no, because if they still to proceed
Exactly.
and not really go after the person behind, they still executing the company agreement.
Right. And so when you read this case, pull up that case, Trustor, that's number 47 on your list. Look at 47. Trustor AB versus Smallbone.
Mas acho que ainda não bem em cases these some weird names.
You could remember these, man. Trustor. It would be good. It would be good if you could get Bahamian cases in a book. I'll see if I can find some Bahamian cases for the final exam. Shut that down.
No one knew. I know. I know. You can stick on schedule.
No, we can stick on schedule the cases in the back, but I could find some Bahamian ones now. You have it, Tessa?
Yes, ma'am. I found the case online. I'm reading through it.
Okay, all right.
So this case arguing the rights of the courts to even do that. I mean, in the
Yes. Mm-hmm.
the pale could say the pale the veil could pierce. I gonna say veil and pierce the same time
Yes.
because there's, I mean, and by law there should be a specific reason or conditions that could even happen.
Right.
So they arguing the circumstance of which that could happen and outline. I still read.
Mm-hmm. Okay.
I think I see Amberzine is in the chat. I don't know if she have any audio, but she's saying some things in chat as well.
Oh. How come she don't have no audio?
No, I have audio. I didn't want to interrupt while others were speaking.
Oh, okay. No, you can join in.
Sorry, I'm in a put you on blast.
No.
Small bonus a crook.
Huh?
Small bonus a crook.
It is not a book. I have it here on one page.
I say he's a crook.
Oh, crook. Oh. In this case, they said courts cannot lift the corporate veil merely because the company is involved in some wrongdoing. The company itself has to be used as a facade to conceal the true facts and the liability of the responsible individuals.
But in this case, Smallbone just misappropriated his position.
So the companies have to also set up to avoid an existing contractual obligation. So it say the claimant argued that three propositions apply to determine when to pierce the corporate veil. One, where the company was shown to be a facade or a sham with no unconnected third party involved. Second, where the company was involved in some impropriety. And third, where it was necessary to do so in the interest of justice and no unconnected third party was involved. And the court said, pierce the corporate veil on points number 1 and 2, but not the third one. So when you talk about piercing the corporate veil as a matter of justice, that was done in the case of Creasy. Let me see if I have that on my list. I don't see it. Creasy versus Beechwood Motors. See if you could find Creasy.
You find a beam against that?
Hmm?
You find a beam against that quick? You say Christy?
No. Will you stop? Creasy, man. Creasey. I think you read today's paper. Why you don't stop?
My bad. I can stop.
Creasy versus Beechwood Motors. You reading it right? Where Mr. Creasy was dismissed from Ms. post as general manager at Beechwood Wellwyn Limited. And he claimed wrongful dismissal. So before he could make his claim, the company ceased trading and all the assets were moved to Beechwood Motors Limited, which continued the business. So they paid off all the creditors, but they didn't pay him. So then he applied for enforcement of the judgment against the new company, Beechwood Motors Limited, and he was successful. So then Beechwood Motors Limited sought to appeal that decision. And what happened? Where y'all finding these long versions of these cases? Okay, so what happened to Mr. Greasy and his money?
Okay, I ain't see that part. Hold on.
What happened to Mr. Greasy?
You say you asked what happens on the appeal.
Yeah, what happened? Because the Beechwood Motors then did an appeal. So
they
the
get-
courts decided that they would lift the corporate veil to enforce Mr. Creasy's wrongful dismissal claim.
Because it's the same directors. They only
There you got it. The
They only
court held that the court held that the directors of Beechwood Motors Limited, who had also been the directors of Beechwood Welwyn Limited, had themselves deliberately ignored the separate legal personality of the companies by transferring the assets between the companies without regard to their duties as directors and shareholders.
Yeah,
So
because
in
they only
that case,
get away from
go
them.
ahead.
They only did
Right.
that to get away from them and not have the obligation to pay him.
Right. And so in that instance, they're saying that they pierced the corporate veil in the interest of justice. So this is the third instance now. The first one we said it was fraud. Then we said agency. And now we're saying in the interest of justice. However, in later cases, they say that the veil should not be pierced merely in the interest of justice. And Creasy was overruled by the case of Ord versus Belhaven, number 27. So look up Ord, O-R-D, versus Belhaven. Found it? But you found out about Ord. Mr. and Mrs. Ord ran the Fox Inn in Lincolnshire. And they were in a dispute with the freehold owner, Belvin Pubs Limited. And Belhaven was part of a group structure that had been reorganized and had no assets left. So Mr. and Mrs. Ord requested that a company with money, Ascot Holdings, be substituted for Bellhaven Pubs Limited to enforce the judgment. So at the first instance, they won. So Bellhaven appealed. And what did the court say?
They determined that the reorganization of the companies was a legitimate one. And so therefore, there was no need to pierce the corporate veil because there wasn't like it was an ulterior motive or something else was going on. They weren't trying to hide finances so that they didn't have to pay. It was just that they did the business the way they did the business. They restructured for internal purposes and it was legitimate.
Right. So it wasn't restructured to avoid an existing obligation at all. It was just doing it for business purposes. And so that's why the case of decision that was made in Creasy versus Beechwood Motors was stated to be wrong. That they should not have pierced the corporate veil in the interest of justice. Because they were not trying to avoid an existing obligation. It was just a matter of restructuring. So you also have, like we said earlier, when there are group companies, and certain cases deal with group companies. So in the case of Adams versus Cape, that's what's number on your thing? Number 1.
For the asbestos?
Yes.
These companies slick now. See,
Not the company is slick.
they arguing they're not liable because of where the registration is.
Mhm. So this involved a claim for asbestos-related injury against the parent company.
They were trying to determine whether or not the UK parent could be considered present in the US for the purposes of enforcing the default judgment,
Okay.
because it was a part of a group or a single economic unit.
Yes.
And they rejected the contention that the corporate veil could be disregarded only in cases where it was being used for a deliberately dishonest purpose.
Mm-hmm. So what did they decide? Because I think they said that they were neither present within the United States and they hadn't submitted to the jurisdiction there. And the court decided to lift the corporate veil. Because the corporate structure was an attempt to evade. So they say Adams versus Cape does support lifting the veil to prevent fraud, but only if the fraud is to evade an existing liability and involves the use of a corporate structure itself. And it also say that for there to be an agency relationship, the subsidiary has to be carrying on no business of its own, but purely the business of its parent company. So you cannot say there's an agency relationship between companies simply because they were part of a group. So in DHN Food Distributors versus Tower, what did the court hold in that case? DHN Food Distributors versus Tower.
Ms. Archer, I want you to know, my partner Graham, she's here now. I
Oh,
want her to
she
get
is.
participation, you know?
Oh, I didn't see she was here. Oh, I see her here. Hi, Shalisa. And Danielle is here.
Good evening.
Good evening. Hi, Danielle. Danielle.
Hi, how are you?
Why you sound like you dead? Wake up.
Hi, Dad. I just got off work.
Oh, okay. All right then. Get a cup of tea
Yeah.
and
So
join
my
us.
bad. I could be late every class because I don't get off work until 6 o'clock.
Oh, okay. Okay. All right. So DHN Food Distributors versus Tower. What happened there? Danielle, I know you're a fast reader, so let's hear it. In this case, the judge
was-
said that, go ahead.
It was one of those cases where you had sort of a parent company and two wholly owned subsidiaries that were really arms of the parent. They had so that they could be treated as kind of a single entity.
Yes. Single economic entity.
Correct.
So the judge said that the group of three companies was virtually similar to a partnership. He said they were bound hand and foot to the parent company. And they had to do only what the parent company said. Therefore, he concluded, the judge, that the group of three companies for the purpose object of the judgment was the right of compensation for disturbance had to be considered as one. And in the same manner, the parent company has to be regarded as that one. So in this case, he said that the parent company was entitled to exercise its right of compensation. So in this case, they pierced the veil of incorporation on the ground of the specific facts related with it. It's also said that you normally don't pierce a group of companies just because of this case. Not in every case. But in this case, the two subsidiaries were both wholly owned and they had no separate business operations whatsoever. So in that case, they were just like how you said, Danielle, it was a single economic unit. So far we said that they pierced the corporate veil in the past due to, what's the first one?
Fraud.
Fraud, second one.
Agency.
Third one. Interest of justice,
Yes.
which was overruled. Creasy was overruled by Ord versus Belhaven. And then we know in group companies, they would pierce the corporate veil when they say that the parent and the subsidiaries are one. However, the last case that we reviewed in Company Law 1 with regard to piercing the corporate veil, which was Press versus Petrodel. What did we learn from that case?
Well, partially it recounted kind of the history of piercing the corporate veil and pointed out cases that weren't really cases of piercing the corporate veil. They were decided on different grounds.
Mm-hmm. Or more or less, he was saying that there were other avenues the court could have taken rather than piercing the corporate veil. So what happened in Press versus Petrodel?
So it was an appeal out of proceedings for ancillary relief following a divorce. It concerned the position of a number of companies belonging to the Petrodel Group. The question was whether the court had power to order the transfer of 7 properties to the wife, given that they legally belonged not to the husband, but to the companies.
Yes, in trust for him.
Mhm.
In trust for him. And why didn't the court decide to pierce the corporate veil? As an evasion principle, which did. And he referred to the case of Jones versus Lipman, Darcy's case. But then he said you can also lift the veil on public policy. So in this instance, the court decided not to lift the corporate veil. What did they do instead?
Trust principles.
First, in this case, first the judge said that despite the confusion in law, the doctrine of veil piercing required some dishonesty on the part of the company member and was not simply a device that could be employed to ensure justice in a particular case. And he said that that was affirmed in the case of Trustor versus Smallbone, in which it was also established that the dishonesty must involve company law being used as a sham or facade to disguise the true ownership of property. And he said that the word sham or facade should be replaced with the words evasion and concealment. He said, if you have concealment of liability, there is no need to pierce the corporate veil, because all that would be required would be to look behind the veil to establish the true actors. So in this case, the piercing of corporate veil would only be possible when company law has been used to evade liability. Although this alone would not be enough, that even where such impropriety had arisen, it would usually be possible to apply another area of law in order to grant a remedy. So in this case, they used trust principles to ensure Mrs. Press was entitled to a beneficial interest in the properties. So after we've gone through all of those cases and all those examples where they pierce the corporate veil, now is being said that you don't know when to pierce the corporate veil, because this case of Press versus Petrodel has thrown everything again in a loop. So they say the case established that although it is possible that the corporate veil may be pierced in some circumstances, it is not clear what those circumstances are beyond the fact that the remedy is only a last resort. And as such, it seems that the decision failed to take advantage of the opportunity to clarify the law. So again, they're saying even after all of these cases and all of these different categories of piercing the corporate veil, it is still not clear as to when the courts will pierce the corporate veil.
So you just gotta roll the dice and take a chance.
You gotta roll the dice and take a chance. Because even in Press, now you know that husband, as far as he was concerned, even when the court had asked him for information, he didn't give it to them because he was sure and confident that they could not pierce the corporate veil. He knew she couldn't get that under company law. He knew that because that's how we had it structured.
But what I try to understand is, in the instance of fraud, that's the case where one is using the company or the pairs that you have a strong enough evidence to prove that to evade personal liability. I mean, and shouldn't that be I mean, and obviously it's not because of the cases that we've read, but shouldn't that be a strong enough case to say, hey, let's pierce this veil?
But see, don't forget now, in one of the cases, they also spoke about whether or not you're trying to evade a future liability. Because we could go back to the case that Tessa read. If you're just doing a restructuring for business purposes, that would be the Ords. Ords versus the Belhaven. How can you justify to say that you were trying to evade? If you're doing a business restructuring, knowing what your liabilities are, you paid some, you didn't pay some. But just because you restructured, that doesn't mean that the liability goes away.
Okay, understood.
Yeah. So a lot of, in each instance, the court has to really look at, should we really pierce the corporate veil? Because like it said in Press, if every time someone comes to the court to say, I can't get my money, I want to go after the persons behind this company, it defeats the whole principle of creating a company. Then what's the use of forming a company if the courts will continuously pierce the veil for different reasons? One being in the interest of justice.
form the company legitimately and be legitimate.
Right, right. There's nothing wrong if one company is in debt and then you close that one and create another one and continue the business, you know, long as you realize that you will have an existing debt. Is whenever you try to do things like they say, like a sham, concealing and hiding. But if everything that you do is in the open, then you cannot say that you're piercing the corporate veil because the company is well aware that they have a debt. And so this whole thing of piercing the corporate veil is still up in the air as to what are the grounds upon which you can actually pierce the corporate veil of a company. So when I give you a question on the final exam, don't pretend you don't know what it's about.
You say you find abatement cases for Joy. Christie versus who?
I was going to say NIGOD, but I changed my mind. I changed my mind. That would not be a good one. I don't think so. That would not be a good one. Huh?
NIGOD versus the Commonwealth of the Bahamas.
For what? What reason? No, not possible. On what grounds? Citizenship? I don't think so. No, 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 no. All right. So we look at piercing the corporate veil. So we know that the veil can be pierced if it's a single economic unit. If the court finds that there's an agency relationship or some evasion of limitation, that's Jones and Lipman, and then evasion of a right of relief, and that was Trustor versus Smallbone. So we know that a company itself it's an individual, an artificial being. Third parties cannot sue the directors. They could only sue the directors when one of them is acting as an agent. And it's difficult for third parties to sue a company directors for liabilities of a company's unfulfilled obligations. Whenever a third party, which is normally a creditor, sue, he has to sue the company. And the director's liability is not limited as the members. And that is why a company always has insurance coverage for liability of its directors. Being mindful that directors in law have a duty of care to the company. And the company in turn can sue its directors for any wrongs that they commit against the company. So if you look at a company itself, remember I said at the beginning that a company has the shareholders and then it has the board. And the board itself has a responsibility to the organization. So remember also that the company can sue the directors if they do not carry out their duties. Anyone could recall what are some of the duties of a director? And you have your company law 1 notes there?
A duty not to make a secret profit.
Yes. What are the duties?
carry out the business of the company.
Yes. There are lots of duties. Come on, let's hear them as what the duties of a director.
Duty of care and attention.
Yes.
Act in the best interest of the company.
Say that again, Amberzan.
I was saying to act in the best interest of the company.
Yes. Any other duties? Don't they also have a duty to act within their powers?
Avoid conflicts of interest.
Yeah, we said that already.
Oh, sorry, I was on. I can't even say mute.
Okay, so avoid conflict of interest. They have the
deal-
access. Go ahead.
Sorry, to deal with and treat fairly the different classes of shareholders.
Yes. What else? Don't they have to exercise reasonable care and skill in carrying out their duties? They also have a duty to promote the success of the company. Don't forget now, as a board member and as a director, they have to carry out or try to achieve the shareholders' strategy. And
No.
more importantly, they have to exercise independent judgment. Because without exercising independent judgment, then they're actually going to be liable to the company for negligence.
Y'all say accepting benefits. Y'all say that one first.
Yeah, we said that one, not accepting benefits.
I going offline. My God.
I don't know what happened to you. So in the Companies Act, under the duty of care, it says that subject to any unanimous shareholder agreement, the directors of a company shall exercise the powers of the company directly or indirectly through the employees and agents of the company. And B, direct the management of the business and affairs of the company. And it says every director and officer of a company in exercising their powers and discharging their duties must act honestly and in good faith with a view, as Amberzan said, to the best interest of the company. And they have to exercise the care, diligence, and skill that a reasonably prudent person would exercise in a comparable circumstance. And the duty and the duties imposed on the directors of a company is owed by them to the company alone. So a director is carrying out his duty. He's not carrying out his duties on behalf of the shareholders. He's carrying out his duty on behalf of the company. And the duty shall be enforceable in the same way as any other fiduciary duty owed to a company by its directors. So first and foremost, you always have to say a director acts in a fiduciary capacity to the company. He must have and he must exercise the care, diligence, and skill that a reasonably prudent man would carry out. He has to comply with the Companies Act or the IBC Act, whichever one the company is under, the statute is under, and he also has to comply with the articles of the company. He cannot be in conflict. He has to act within his powers. promote the success of the company, exercise independent judgment, and avoid conflicts. Don't accept any benefits from third parties. And he also has to make sure that he declares any arrangements or any transactions that he has or will enter into that would be in conflict with the company. And all of his general duties, he owes them to the company, not to any individual shareholder, because it's the company that can sue the director for breach of duty. Who brings an action against a director? Who can bring an action against a director?
The company,
Who starts it? Where does it start?
Shareholders.
No, the board. The board brings it. The board will bring it against the director. Now, there are certain instances where an individual shareholder can bring a claim. And they would actually do that on a breach of duty, if he breaches his duty. Now, when it comes to the Solomon principle, remember going back to the case of Solomon versus Solomon, when he put all of his assets in the name of the company. A lot of shareholders, when they purchase a company or they acquire a company, they always are under the impression that the assets of the company belong to them personally. Once the company is formed and the assets are in the name of the company owns that property, not the individual shareholders. And the company doesn't hold the assets as trustee for the shareholders. Additionally, the shareholders do not have a legal or equitable interest in the assets of the company. And a lot of foreign shareholders from non-common law countries have this conception in their mind that the assets of the company belong to them personally. And that that they hold an interest in the assets of the company. And that is not so under common law. Now, a company itself, as an artificial being, can sue and be sued. So let's look at under contract. If a person enters into a contract with a company and they want to enforce it, who do they approach to enforce the contract with the company?
they have to enforce it against the company.
Yes, and who in the company? It has to be the person who has the authority, right?
Signing authority.
The signing authority. Whoever's the executing officer must have the signing authority in order to enter into that contract. Can a shareholder enforce a contract?
No, not if the
No.
contract is in the name of the company.
Okay. Again, you would have foreign nationals who have a company incorporated in the Bahamas, and they are of the view that even though they are a shareholder, that they can enforce a contract of the company. And they do not understand that concept that cannot happen. because the shareholder is not a party to the contract and he is not entitled to any benefit of the contract. All the benefits belong to the company. And it's vice versa. A shareholder can't be sued on contracts made by the company. And a court can't compel a shareholder to vote at a general meeting that will ensure that the company will fulfill its contractual obligations. It can't do that. So that's contracts. A company can sue in respect of torts committed against it. And for a tort to be committed is normally committed through either its employees or the directors. And we know that a company is liable for any acts of its agents, as long as they're acting in the course of the employment or within the scope of their authority. Now, a director may be liable with the company as a joint tortfeasor. And that's where he is either authorized, directed, or procured the wrongful act. But if he is carrying out his duties, as stated in the memo and arts, then the circumstances for him being a joint tortfeasor would be infrequent. So as a director, you have to always make sure that you read the memo and arts to know the extent of your authority so that you never act outside of it. Because then you end up being a joint tortfeasor to whatever crime is committed. So it said a director will be liable with the company as a joint tortfeasor if he participates or is involved in the wrongful act that goes beyond the exercise of his control set out in the memo and arts. And a director is liable for his own tort, regardless of whether or not he is a director. Look up the case now of Standard Chartered Bank versus Pakistan National Shipping Corp. That was an interesting case. Standard Chartered Bank versus Pakistan National Shipping Corp. Amberzine, you found it?
I'm looking right now.
This is where there was some fraudulent bills of lading that were issued. And relied upon for some letters of credit issued by the bank. And what the director did was he signed the bills and then he tried to avoid personal liability. by saying it was the act of the company.
Boy, this sound like a Bahamian case too, but anyway.
Can you find a short summary?
A company director was accused of fraudulent misrepresentation. He could not escape liability on the basis that the fraud was not committed on behalf of himself personally, but on behalf of his company. Held, fault was defined as negligence, breach of statutory duty, or other acts or omission. It was argued that the conduct by the claimant could not amount to fault within the act unless it gave rise to a common law defense of contributory negligence. There was no common law defense of contributory negligence in the case. So no apportionment could be made. And the defendant's liability arose from having committed fraud, not by virtue of his position as a director. So the actual director had committed fraud.
So if you look, it says a director may also be liable for negligent misstatements if there is an assumption of responsibility and reliance on the assumption. He was the only human involved in making the representation to the bank. So the managing director was being sued, not for the company's tort, but for his own tort. So he was not liable because he was a director, but because he committed a fraud. And then criminal law. A company is subject to criminal law as any other person. In some instances, liability may still occur even though the company's management had forbidden its employees to behave in a particular manner. And in these instances, the court seeks to determine who is the directing mind and will for the purpose of liability. Let's look up Meridian Global Funds Management versus Securities. Shalisa, that one is for you.
Can you give me the case again, please?
Meridian Global Funds Management versus Securities.
This is you said, Meridian Global Fund Management Asia Limited versus the Securities Commission?
Yes.
Okay. 1 second, I read kind of slow, so.
Okay.
1 second.
Next time I see you, I'll lend you an old pair of my glasses. So you can read faster.
It was in China. It's in Asia.
Are you looking anything up, Darcy, or not?
They say Meridian was part of a syndicate within the takeover
Yes.
a New Zealand company,
Uh-huh.
and they failed to disclose to the Securities Commission that they had become a substantial security holder of over 5% of the company and wanted to hide the transactions from
Yes. Huh?
their.
Darcy, how you find out already?
Hold on, I
You
wasn't
trying to
looking
tell
at.
me? Hold on, Shalisa's not found this case yet?
I think you need to go back to
I
my.
found the case, but I on Case Mine and I trying to read through.
Oh.
Table, how much I sent me my bill? I fallen off a little bit. That you see, does have to deal with the work.
Yes.
It
But
is
that's
can
your
me.
partner.
It is can me hard the work.
This is company law. This is not Bank of the Bahamas. Let's keep it in the classroom. I can deal with you tomorrow.
Note the file.
Mm-hmm. So you're in Case Mine, where they say in 1990, a group of people in New Zealand, Malaysia, and Hong Kong tried to gain control of a cash-rich, publicly listed New Zealand company called ENC
Mm-hmm.
and use its assets for their own purposes. That's the first no-no. The predators included a New Zealand businessman called Mr. Mon, two Hong Kong investment managers called Mr. Koo and Mr. NG. And they were employed by Meridian Global Funds Management Asia Limited.
Mr. Na,
The case went to talk on too about how it looks like they were in breach of some of their duties as directors. And that they weren't transparent into dealings in public quoted securities. And they went on to list the things that they did not disclose.
Okay, look at this say. The intention was to fund this purchase out of ENC's own assets. But bridging finance was needed to fill the gap between buying the shares and gaining control of the company's monies. So this was provided by Koo and NG out of funds managed by Meridian. Don't forget that they were investment managers and employed by Meridian.
Right. But bridge finances was needed to fill the gap between buying the shares and gaining control of the company's money.
So they funded the scheme by improperly using their authority to buy and sell Asian shares. So they contracted on behalf of Meridian, the employer, through this company, Wang Yusof, to buy a parcel of shares in Malaysian and Indonesian companies from ENC.
Wow.
And then at the same time, to resell the same shares to ENC
At
for a
greater
higher price.
Right.
But the scheme to pay Meridian back the money was frustrated by the independent directors of ENC, who imposed conditions on the use of the company's funds with which the creditors could not comply. So unable to get their hands on the company's funds with which the creditors could not, unable to get their hands on the company's money, they had to unwind the scheme as best they could. So they tried to extricate themselves except to notice two matters. I'm saying this sound like another Bahamian model myself.
Ms. Archibald,
They just do the same foolishness.
I know.
And try back out after they get catch and get messy.
Well, I ain't like I always say, but I'ma sound like Soto.
Yes. You can put Bahamian names right in these same things.
That's right.
It's the same thing.
I
I'm
know that
like,
case you talk about is you talk about KC.
Yeah.
So it says here that Judge Heron held that Meridian knew on the 9th of November that it was a substantial security holder in ENC for the purposes of the section of the act. He arrived at this conclusion by attributing to Meridian the knowledge of Koo and NG, who
Mhm.
undoubtedly knew all the relevant facts. He did not go into the judicial basis for his attribution in any detail. It seemed obvious to him that if Koo and NG had authority to enter into the transaction, their knowledge that they had done so should be attributed to Meridian.
Mhm.
It had therefore been in breach of his duty to give notice under section 20, subsection 3. In view of the fact that its relevant interest had ceased on the 10th of December, the judge made no order against Meridian, except that it should pay $15,000 towards the commission cost and $15,000 towards the cost of a minority shareholder at ENC. The finding that Meridian was in breach was incorporated in a declaration made by the judge at the request of Meridian so that it could have an order against which to appeal. The Court of Appeal affirmed the decision of Judge Heron on somewhat different terms. It decided that Koo's knowledge should be attributed to Meridian because he was the directing mind and will of the company. The Court of Appeal received some evidence about how Meridian functioned. The members of the board lived partly in Hong Kong and partly in Australia and met only once a year for the formal business before the AGM. Other matters which required a board resolution were circulated by post. Koo used to be the managing director, but was replaced by Mr. Amoir on the 1st of August. Although Koo thereafter, in theory, reported to Mr. Amoir in the matter of buying and selling securities, he went on in the same way as before. The ENC purchases and sales were openly recorded in the books, but Koo did not specifically report them to Mr. Amoir, who only found out about them after Koo had left. Nor did Koo report anything else, and there was no evidence that Mr. Amoir or the other members of the board tried to supervise what he was doing. By leave, the Court of Appeal, Meridian now appeals to their lodge's board. It says that its only directing mind and will was that of its board, or possibly of Mr. Amoir, and not Koo, whom the Court of Appeal correctly described as under Mr. Amoir in the corporate hierarchy. Come on, Chalisa, what else they say?
The phrase directing mind and will comes, of course, from the celebrated speech of Viscount Haldane LC and Leonard's Carrying Company Limited versus Asia Tech Petroleum Company Limited. But the lordships think that there has been some misunderstanding of the true principle upon which the case was decided. It may be helpful to start by stating the nature of the problem in a case like this, and then come back to Leonard's case later. Go on. Any proposition about a company necessarily involves a reference to a set of rules. A company exists because there is a rule, usually in a statute, which says that the persa facta shall be deemed to exist and to have certain of powers, rights, and duties of a natural person. But there would be little sense in deeming such a persona facta to exist unless there were also rules to tell one what acts were to count as acts of the company. It is therefore a necessary part of the corporate personality that there should be rules by which acts are attributed to the company. These may be called the rules of attribution. The company's primary rules of attribution will generally be found in its constitution, typically the Articles of Association, and will say things such as, for the purpose of appointing members of the board, a majority vote of shareholders shall be a decision of the company, or the decision of the board in managing the company's business shall be the decision of the company. There are also primary rules of attribution which are not expressly stated in the articles, but implied in by company law, such as the unanimous decision of all shareholders in a solvent company about anything which the company under its memorandum of association has power to do shall be the decision of the company. See multinational gas and petrochemical company versus multinational gas company services limited. Go on.
No, go further down. It says, it was therefore not necessary in this case to inquire into whether coup could have been described in some more general sense as a directing mind and will of the company. But their lordships would wish to guard themselves against being understood to mean that whenever a servant of a company has authority to do an act on its behalf, knowledge of that act will, for all purposes, be attributed to the company. It is a question of construction in each case as to whether the particular rule requires that the knowledge that an act has been done or the state of mind with which it was done should be attributed to the company. Sometimes, as in ready mixed concrete and this case, it will be appropriate. Likewise, in a case in which a company was required to make a return for revenue purposes and the statute made it an offense to make a false return with intent to deceive, the divisional court held that the mens rea of the servant authorized to discharge the duty to make the return should be attributed to the company. And I tell you, see the case of Moore versus I. Besler. On the other hand, the fact that a company's employee is authorized to drive a lorry does not itself lead to the conclusion that if he kills someone by reckless driving, the company will be guilty of manslaughter. There is no consistency. Each is an example of an attribution rule for a particular purpose, tailored as it always must be to the terms and policies of the substantive rule. So in this case, what did the court conclude?
The court concluded that it didn't really turn on whether or not he was the directing mind and will of the company. There was a particular obligation on the company to do a thing, which was report.
Exactly.
Yeah. And the
I want to
company
see if
failed to
Charlisa
do
got
that
it.
thing.
Go ahead. That they failed to do that thing. You get that, Charlisa?
Yes, ma'am.
Okay. So if I were, let me find another question since everybody is on now. You know, I have another question. If I refer to, let me get you the section in the act that I want to turn to. If I quote you Article 11 of the Companies Act, which states, the articles, when registered, bind the company and the members thereof to the same extent as if each member had subscribed his name and affixed his seal thereto. And there were contained in such articles a covenant on the part of himself, his heirs, executors, and administrators to conform to all the regulations contained in such articles, subject to this act, and all monies payable by any member to the company in pursuance of the conditions or regulations shall be deemed to be a debt due from such member of the company. What does that mean? Section 11 of the Companies Act. Or put it in another way, what is the legal effect of Article 11? Or what is the legal effect of articles?
That this is a binding, once the articles are registered, it binds the company and its members,
Mm-hmm.
and that then affects put in the effects the articles of the company.
Mm-hmm. So the first thing we know is that the memo on arts is what? A contract
Mhm.
between the company and its members.
Right.
And then each member in his capacity is bound to the company by the provision of the articles.
Mhm.
And even though it doesn't say so, if you read it again, you would you more or less infer that the company is regarded as bound to each member in its capacity as a member to observe the provision of the articles.
Mhm.
So it's a contract between the company and its members.
I think it's also noteworthy, Mrs. Archer, that it's like in perpetuity because it talks about heirs and everything.
Yes,
And
yes.
executors and administrators, right? So it's
Mhm.
not even just members, but as long as the company is in existence, you're bound, and everyone after you is bound.
Exactly. So let's get another point now. We know it's a contract. We know that the members are bound. So we also know from this that one member can sue another if they fail to observe what's in the memo on arts. And it also tells you in this section 11 is that a member doesn't have any other right than that right to act in that capacity as a member. And the memorandum and articles is not a contract with outsiders, but only with its members. Do you think that section 11 gives members the right to sue the company? Or that they can enforce their rights
I would
via
think
the
so,
company?
eh?
Yeah, if it's a
If
contract.
if they ban, yeah, if it's a contract.
Yes.
If anyone is in breach of it, then it's subject to being sued.
And I'm trying to see if, I don't think they changed the wording of this. No, they didn't. Okay. So based on all of the cases that we covered tonight, and based on a company in its day-to-day dealings, I'm going to send you a homework question. And I want you to tell me or advise what should be done. So it's going to be a company question from anywhere in company. Something being done by the directors or something being done by the shareholders. And then that will be the end of company itself. Because remember, tonight is just a recap of the principles of company law. Because the course looks at other types of vehicles that are used in conjunction with companies in order to carry on business or to structure your business, either as a local entity or a foreign entity.
Company graduation and gone.
What's wrong with you, Darcy? We're in 2021 now. Not so long ago. Where you just coming from with these things? So next week we'll look at type of companies. But before we begin that, we will look at the question that I will send you all. Any questions?
Nope, sounds good.
Sounds good?
Yep.
Okay. Very good.
When
So
is
I'll
it,
find it.
when is it due?
What? Now listen here. What did I just say? We are discussing it before we begin chapter 2.
Oh, so you don't want to see it back from us?
Well, of course.
Submitted it by email
Yeah.
by next class, which is Monday.
Yes.
Okay.
So we should have it to you before the class start.
Yes. That don't mean
Okay.
at 6 o'clock now. Don't try it. I know how y'all go. Not
see-
at 6 o'clock. Hey, and I
see
know
the tact.
Danielle.
I see the tact.
Hey, Danielle could try to send it to me on Monday because she could say, well, I'm gonna do it on the weekend.
So
I know.
question then, from,
Okay.
how do I get the recorded version of the class? Because like I say, I don't get off at 6, and by the time I drive home, I'm almost always gonna be late and miss the beginning. So how do I get a recording? of-
Miguel said it at the beginning.
On
On YouTube.
On YouTube.
Okay, but I wasn't here at the beginning. That's the whole point.
Let me give you what he said.
Yes, on YouTube.
It's yeah, Biff's edu.
Yeah,
On
Biff's
the
EDU.
channel, yeah, EDU on YouTube.
Okay, thanks.
And if you don't find it, just call Miguel. I give you the authority to
Okay.
harass him to death.
Thank you.
All right. So
Okay.
look forward to your homework question. It will be coming.
So we on
It's
the
already
road
here.
I'll be sending your homework question. What'd you say?
Send that so fast.
I've not sent it yet.
So what's all of these questions I see? Those were for tonight?
Yes,
Those
we
were-
discussed those
in the
tonight.
class, Yeah.
Okay.
We discussed those tonight.
Okay.
Yeah. We discussed those tonight. All right. So happy reading. And let me formulate something for you all to sink your teeth into. Oh, yeah. All right.
Okay.
So
Thanks.
enjoy the rest of your week.
You do the same.
You
Okay.
too.
Thanks, Ampersand. Okay, Danielle.
Thank you,
Bye,
everyone.
Shalisa. Bye, Tessa.
Good night.
Good night.
Bye.
Where's Darcy?
All right, Miss Sacho.
You trying to do too many things. What time? Bye.
Bye, ma'am. Take care.
Bye. All right. Talk to you
See you
later.
next week.
Okay.
You putting on your video next week, right?
Say what?
You putting on video next week, right?
If you wish, I can.
No, I ain't asking. I was just testing you. See you later.
All right. Bye.
Bye.
Okay.